So we'll get back to what brought us here today. and as always, we start out with what's going on at the state level, and we start out with the National Parents Organization scorecard. So taking a look at that, the state of Missouri grades out as a C+, which is average, maybe a tick above average in terms of where it sits compared to the other states. Now, there's been a lot of movement, and you're obviously someone who's been on the ground and been testifying. So dating back all the way to 2016, there's been a ton of activity, but maybe not a ton of movement in the state of Missouri. Do you kind of want to tell the viewers about what we've had going on?
Sure, yeah. So first, before I start, big shout out to NPO. Just some fantastic folks there, and they have done a lot of background work in getting surveys done that we'll be talking about this throughout the weekend, but that have been instrumental in getting the nation's best equal shared parenting law passed in Arkansas. They did some similar survey work for Missouri as well. So great job by our team there. Missouri started. This will be coming up. Will be our 8th year. And it started, so a few years before, I guess around 2014, 15, is when bills started to get filed. 2016 was a bit of a watershed year because that's the year we first got into statute terms regarding equal parenting. It didn't quite make it into where it needs to be in terms of what we call a rebuttable presumption. And that's what that is just sort of like a starting place. So, if you think of a football game, instead of starting at, in the end zone or at the, anywhere like the 20 yard line or whatnot, why are we not starting at the 50-yard line? So that all began in Missouri in 2016. And what happened in 2016 is a change to the statute. It was 452.556.1. And basically it said that court clerks are required to create a handbook to help parents create a parenting plan. And in so doing, the language was they have to create guidelines as to what to include in a parenting plan. And here's the key: in order to maximize to the highest degree the amount of time the child may spend with each parent. Great sounding language. It's just not beefed up in the right place. And in the right part of the statute. And we need something that directs the judiciary to say, this isn't a clerk creating guidelines for a handbook. This is the judge saying, we're starting at 50-50. Now, some do. Some do. The problem is, our counties are, if you've got counties here in the St. Louis metro area, you've got a couple counties divided by the Missouri River. And the problem is you can start with a judge in one county who says we're starting at 50-50. You can go 20 minutes across the river and get the exact opposite experience. And that just shouldn't be the case because it's a state law. It needs to be applied consistently, regardless of the courtroom you're in, the judge you have, the lawyer you have. So that's why we need to give it, and we've been working since 2016 to say, well, now we've got, the basics, the model. Now we've got to give it some teeth and say, here's where you start. And it ought to be that you shouldn't have to prove you're a good person. I mean, I hate to compare it to sort of criminal law, but in criminal law, we've often heard, you're innocent until proven guilty. You don't have to prove your innocence legally in criminal court. So why is it any different for a parent? Why does a parent have to come in and prove I'm a fit parent? I mean, the presumption, and there's some U.S. Supreme Court cases that say, a parent is presumed to be fit. Well, if that's the case, if you're presumed to be fit, then you shouldn't have to prove that. The burden should be on the other side, the parent who believes you're not fit, to prove you're not fit. And so that's what, the intent of our work, our lobbying, our legislative drafts are to say, no judiciary, you start where they're both fit, they have equal time. If someone is offering why there should not be equal time, well, they've got to come forward and prove it. Otherwise you shouldn't be spending tens of thousands of dollars and years of time to get that time with your child. I'm fond of saying, there's no point going to court to get more time with your 5-year-old if by the time you get it, they turn 18 in 3 weeks. or they turn 8 or they turn 10. You're wasting time.
One of the things I always use, the viewers always hear me use, is when we're creating this change, and obviously there's a group of us here this weekend going to be working towards hopefully creating some change, but the first downs. Right now, we don't start on that 50-yard line.
That's right.
And in every single state, we have to continue to work and to get those first downs. In a state like Missouri, there's been a ton of activity, but we saw, I think it was ended up being 6 states last year that passed some form of improvement.
Yeah.
And you kind of mentioned the 3 prongs we're looking for. We're looking for that rebuttable presumption. We're looking for the burden of proof to rebut that presumption, and then facts, findings, and conclusions if that presumption is rebutted. So there's some accountability.
Well, and that's the other part of the change in 2016 that happened is part of that law said judges have to enter facts, findings, and conclusions of law for their judgments. So they can't just sort of willy-nilly say, well, I'm going this way and da-da-da. No, they've got to have, something substantive justifying their order. It also comes after. So that's the aspect of the law that happened in 2016. After that law went into effect in August of 2016, there's a very important case that came down in Missouri called Morgan v. Morgan. And Justice Page did a terrific job analyzing the custodial statutes in Missouri, as well as this new law. And she said in her opinion, the intent of the legislature is clear. Joint custody is favored. And look at this language about creating the handbook. It says to maximize the time with each parent. So what we're going to interpret that new law is saying is it ought to start at being equal. The problem is it's just with so many different counties, so many different courts, it's just not been strong enough. And that's why we need to create a follow-up bill like all these other states are now doing. And we've worked with half dozen, 8 or 9 different states like Arkansas, like Wisconsin, like Michigan. That's the great thing about volunteering for an organization like Americans for Equal Shared Parenting, even though I'm Canadian. Canadians are for it as well. Is we've been able to work with all these different groups, like NPO, like the folks in Arkansas, to draft core quality legislation that's consistent. It's consistent from each state. So we're basically in the process of drafting and eventually adopting a uniform statute on equal parenting from the beginning. And it's just from the beginning. I get if there's other issues, that's fine. You got to come into court and you've got to prove it. You can't just, make allegations in a pleading, because what often happens is, in some of these counties, I practice in about 4 or 5 different counties here in Missouri, and they're all about 3 or 4 months away from your initial case management conference. So someone files their petition for custody or divorce, and you're looking minimum at 4 months before you get in front of the judge. And even then, that's just a case management. That's nothing substantive. Might be another 2 months before you get there on an evidentiary hearing or an evidentiary motion, basically a motion for temporary custody. That's 6 months. If you haven't seen your kid in 6 months and that kid is 3, 4, 5 years old or however the age, that is a huge problem. So what our attempts are in drafting this legislation is we also need to get a temporary order done within the first month. So here's the deal, and this is the standard. It's not, you can still vary it in terms of, even though it's 50-50, you can achieve that a number of different ways, week on, week off, 2 days, and then 3 days over the weekend, every other day if they're a young kiddo. So it's not, we're not forcing, some default thing. You can still vary it. We're just saying the default presumption from the beginning is equality. And that's what this country was founded on.